Hey all, welcome back to the Law Read Slowly. In the last session, we completed our discussion on Introduction to Pleadings, Plaint and Written Statement. We read a number of provisions from the CPC and we took a number of examples for those provisions because my goal was that CPC is one of those laws which does not have any illustrations for you. It has here and there few illustrations, but it's not full of illustrations like other laws. You have IPC, you have your CRPC, now you have BNSS. They have illustrations to make a point, but CPC doesn't have any illustrations. So we used each provision that we read and we took illustrations around that provision so you can visualize what is being said in those rules. And once you start visualizing, the law starts to stay with you and then you don't have to cram it specifically. It automatically stays with you because then you remember the situation and you remember the point in law. Clear? Today we have to discuss some terms. We have to discuss cause of action. We have to discuss title, we have to discuss subject matter, we have to discuss matters in issue. We have to discuss all these terms today. And it's a very interesting set of terms because once you understand their meaning, you feel so confident because it's something that a lot of people end up confusing with each other. We've already had a long discussion on cause of action. We have finished cause of action as a topic in itself. What is cause of action? Cause of action is a cause which leads you to take the action. What is this action? Filing of the civil suit in question. What will your cause of action be? It will be that there was a right that you had which was violated. So every plaint has to contain a cause of action. Where have we read this? Order 7, Rule 1 tells you specifically that cause of action has to be there in a plaint. We read it yesterday. And if you don't include the cause of action in your plaint is liable to be rejected under Rule 11 of Order 7, Subclause A. So you have to include the cause of action. We've already discussed cause of action. I've also given you something to write on cause of action so it stays with you. But just revising it because these are different terms and the point is for you to understand that not only their meanings in themselves but also to be able to remember the meaning so well that you are able to differentiate between them. So cause of action we have already done, we have revised also, and we have also discussed that there for certain civil wrongs or for certain remedies to be claimed, there has to be certain cause of action which has to be proved. So generally the cause of action is going to constitute of what? Existence of legal right and violation of that legal right. That's all. That's the basic structure of a cause of action. But for certain scenarios, for example, where you're claiming specific performance of a contract, we have discussed that your cause of action is laid down by the law, which will include any extra elements that the law prescribes. So Specific Relief Act specifically prescribes an extra condition. What is that condition? That not only should you have a right which is coming out of the contract, not only should you also write a breach of that right, which is what? Breach of contract. You should also mention that you were always ready and willing to perform that contract in the first place. That is, you should come to law with clean hands. So that is an extra element that you have to prove in order to constitute a complete cause of action. So if you don't prove your readiness and willingness to perform the contract, then your cause of action will be said to be incomplete. An incomplete cause of action will not count as a cause of action at all, and hence your plaint will be said to be devoid of a cause of action, hence liable to be rejected under Order 7, Rule 11, Subclause A. Understood? So that is cause of action for you. Now other terms. Visualize this, that when you file a suit, does anybody go file a suit for anything? Like if I'm not related, so if there's something happening in the street, there's some kind of civil wrong happening, will I be able to just go file a suit for it? No. Filing a civil suit and getting a civil remedy is a very in personam right. So you have to have some kind of locus, some kind of relationship, some kind of involvement in the factual scenario of the suit that you're filing. You have PIL, your public interest litigation that you can do, but civil suit, you have to have some kind of locus standi with respect to the subject matter of the suit, with respect to the thing with respect to which you're suing. So what? So if there's a house, two brothers are fighting on the possession of that house. One is saying, I own the house. The other is saying, no, I own the house. I am their neighbor. Can I go to the court and file a suit? No. Court will be like, why are you here? If they are okay with fighting amongst themselves and resolving the issue or sitting together and resolving the issue, What is it to you that you are forcing them to come to the court? You can't force anybody to go to the court when you yourself have no interest in that factual scenario. You yourself have no interest to be gained from the decision of that suit. You don't. So how can I go and file a suit for that house and talking about their possession? No. So everybody has to have their interest in the suit. You have to understand this point, because our discussion, this will help you understand these different terms. So we say that what do you file a suit for? You always file a suit for something. If there will be something that you want, there will be some kind of thing that you are filing the suit for, only then will you file it. You won't just file the suit for the sake of it, that, oh, I need a case in the court with my name in the title of that case. No, that's not a reason for you to file a civil suit. Cause of action. When does cause of action arise? Because there was a thing that you were entitled to and you were denied of that thing. So you had a right to have that thing, and your right to have that thing was denied, violated. Now this thing about which the suit is called your subject matter. That's the term we use. So subject matter of a suit means the thing with respect to which the suit has been filed. Now what can this thing be? This thing can be money. This thing can be property. This thing can even be just a right with respect to something. How can it be? So money, you have suits. If I have borrowed money from you and now I am refusing to pay that money back to you, so you will go file a suit for recovery of money. So what is this money for? What is the thing you're trying to get in this suit? The money. So the thing, the subject matter can be monetary, pecuniary. You can get the money. Money is the subject matter of this suit for money recovery. Suppose I am a trespasser in your land. You want to eject me from that land because you want the possession back. I am not leaving that land because I am trespassing and I am sitting there. So you file a suit for recovery of possession of the land. Now here what becomes your subject matter? Your subject matter of the suit is that land. But the subject matter of the suit can also be called what? The right to possess that land. The right to possess that land. So the right itself, that right to possess, becomes subject matter. So the subject matter can be land and or the right to possess the land. Both are correct. Because sometimes suppose you have a property. You are a tenant in that property. Somebody is the owner. You have rented that house from them. I come and I try to disturb your enjoyment of that house. Because right to possess is what? Right to possess is right to enjoy. Ownership is what? Right to own. So as a possessor, as a tenant, somebody who only has a right to possess, to live in that property, you only have a right to enjoy that property. Do you have a right to sell that property? You don't. So primary right of any person who is in possession of a property is to enjoy that property. Because if you can't enjoy your property, what is the point of you even being able to possess it? Merely sitting inside the house, locked inside a room, it's not the point. The point is to be able to make full use of that house, enjoy that house. So I am somebody who is trying to disturb that right of enjoyment that you have as a tenant, that you have as somebody who is in possession of that house. So even if you don't have ownership, you have possession by way of tenancy of that house. Why did you take tenancy in the first place? Why did you take that possession in the first place? So you can make use of that house so that your family can live there, so that you can live there, so that you can use that house in whichever way you want to use. But I am, suppose, your neighbor. You have a garden in that house. You want to grow a kitchen garden there. You're planting chilies, you're planting different kinds of little vegetables in that garden. I have a very rowdy dog, and this dog, I let him loose. And this dog comes to your garden and runs all over, damages your garden. Every other week, it's the same story. So I am doing what? I am violating your right to enjoyment of that house. So what will your subject matter? If you file a suit against me to get an injunction against me, what will that injunction be against? That suit that you will file is to stop me from violating your right to enjoy, your right to possession of that house. Possession itself means that you have a right to enjoy it. So you're filing for your right to possess the house. So what are you filing? What will the subject matter of this suit then? Subject matter of this suit will be your right to possession of that house. Garden is part of the house, right? Right to possession of the house will become the subject matter of that suit. An injunction is the relief that you get to stop somebody. When you have to stop somebody from doing something, you get an injunction passed against them. So you will get an injunction passed against me from disturbing your right to enjoy the right to possession, right to enjoyment of that house property. So the right to possession of the house becomes a subject matter. What else can be subject matter? Subject matter can also be your right to your reputation. So if I am publishing some defamatory material against you, you can file a suit to stop me. Why? What are you trying to get out of that suit? You're trying to get out of that suit the right to your reputation. Everybody has a right to have their reputation maintained in the society. And how does that right to reputation get violated? When somebody defames them, when somebody publishes material which is not true and is defamatory to their reputation. So if you file a suit for defamation, what will be the subject matter of this suit? Subject matter of this suit will be right to reputation. So even personal rights like right to reputation, right to free speech. Right to free speech can also be a right, that if you file a suit to exercise a right for free speech and somebody else is violating that right, then what are you claiming here? You're claiming that my right to free speech should be protected. So right to free speech can be your subject matter in a suit. We have seen different cases. For example, you have a right. So for example, there's a temple and the temple has a chairman of the committee that runs the temple. There's a chairman. You contest the election, you win fair and square, you get the votes. Now there's a miscreant who was a runners-up, and now he's trying to disturb your right to be the chairman, your right to run that committee. So that right is a civil right, it's the right of civil nature. So that right you can file a suit that I have been elected to this temple's chairmanship and this person is disturbing that right. So what will be a subject matter here? The subject matter will be your right to the chairmanship, your right to possess and exercise the power of chairmanship.